Hello everyone. Today we will discuss about contract of indemnity. Contract of indemnity, you can also call it as per the literal meaning indemnity. Indemnity is what? Indemnity is protection. Now, contract of protection. So the protection is regarding what? So let's have a look at the same. Now this particular contract has been defined under section 124 of Indian Contract Act. A contract by which one party promises to save the other from the loss caused to him by the conduct of the promisor himself or by the conduct of any other party is called the contract of indemnity. Now, one party is promising to protect the other party from what? From a particular loss. So now you can qualify one thing, that there are two parties. So who are the two parties? The party who makes the promise to the other party is called the indemnifier, and the person who is given the promise is called the indemnity holder. So to make it simple, a contract by which indemnifier promises to save the indemnity holder from loss caused to him by the conduct of the indemnifier himself or by the conduct of any other person is called the contract of indemnity. So this loss can be by the conduct of the indemnifier or by the conduct of any other person. So this is what is contract of indemnity. So there is a case, New India Insurance Company Limited versus State Trading Corporation of India. In this particular case, Gujarat High Court have given a kind of exception to this particular contract of indemnity. Gujarat High Court has stated that all kinds of contract of insurance are under the category of contract of indemnity, but there are exceptions to the same. Life insurance and personal accident insurance are not coming under the category of contract of indemnity. Take another example. A contracts to indemnify B against the consequences of any proceeding which C may take against B in respect of certain sum of rupees 200. This is what? This is the contract of indemnity. Next, what are the modes of a contract of indemnity? So there are two types of modes, expressed and implied. Expressed mode, when a person expressly promises to compensate the other from loss. Implied mode, when the contract is to be inferred from the conduct of the parties or from the circumstances of the case. So it depends on the actions of the parties basically. Next, what are the essential elements of a contract of indemnity? So first and foremost, essential element is that there are two parties, indemnifier and indemnity holder. The person giving promise to compensate is indemnifier, and to whom the promise has been given is called the indemnity holder. Next, all the essential elements of a valid contract given under Section 10 of Indian Contract Act have to be satisfied over here to make a valid contract of indemnity. Third is loss to one party. So loss is again one of the very basis of this contract of indemnity. Without loss, there can't be any sort of contract of indemnity. The person can indemnify another person only if such other person incurs some loss or it has become certain that he may incur some loss in future. Indemnity by the promisor. The purpose of contract of indemnity is to protect the indemnity holder from any loss that may be caused to the indemnity holder. Next is contingent contract. Why we are calling indemnity contract as contingent contract? Because contingent contracts are what? They are conditional contract which depends on happening and non-happening of a certain event. So in this contract of indemnity also, it depends on happening or non-happening of a particular loss. That's why it has been quoted here that the person will incur some loss or he may incur some loss. That's why both of the happening and non-happening has been given. That's why it is called a contingent contract. Next essential element is reason for loss. The contract of indemnity must specify that the indemnity holder shall be protected from the loss caused due to first action of the promisor or the indemnifier himself, or action of any other person, or any act, event, accident which is not in the control of the parties. Next, rights of the indemnity holder. Now, these rights of the indemnity holder has been specifically given under Section 125 of Indian Contract Act. First and foremost right given under Section 125 is right to recover damages. Now, the indemnity holder has the right to recover all kinds of damages which he is compelled to pay in any suit in respect of any matter covered by the contract of indemnity. Now, in this particular damages, the indemnity holder has been forced to pay that particular amount in a suit, and that particular matter should be covered or should be under the ambit or scope of the contract of indemnity. Second, right to recover costs. The indemnity holder has the right to recover all the costs which he is compelled to pay in bringing or defending such suit. Whatever amount he has spent while bringing a particular suit or defending that particular suit, or he was forced to compelled to spend, can be recovered. So he has a right to get it recovered. Next we have his right to recover sums paid. The indemnity holder has the right to recover all the sums which he has paid. Now the sums is directly connected to compromise, which he has paid under the terms of a compromise of such suit. Now, for the right number 2 and right number 3, right to recover costs and right to recover sums paid, to take both of these right or to apply for these two right, two conditions have to be foremostly satisfied. The condition number 1, the indemnifier authorized him to bring or defend the suit, or the indemnifier authorized him to compromise the suit. Means this particular suit which has been brought or which he has defended, it should be on the instructions given by the indemnifier. Next, for item number 3, the indemnifier have instructed him to compromise that particular suit. Second essential condition is the indemnity holder did not contravene the orders of the indemnifier. Means the indemnity holder didn't went against the orders given by the indemnifier. Means he has followed all the orders or instructions which were given by the indemnifier, and the indemnity holder acted as it would have been prudent for a reasonable man to act in the same situation in the absence of a contract of indemnity. So this is with regard to all the rights which the indemnity holder is having in the contract of indemnity. So we are done with this contract of indemnity. Thank you.